On the record in the matter of Manor born LDHA versus Lakia Hester, 25-02762, appearance please.
And Max Fieldwood on behalf of plaintiff, Your Honor.
Your name, ma'am?
What'd you say?
What's your name?
Lakia Hester.
Okay, you can remain standing. It says, are you in the fire? Okay, today was the date that was scheduled for a hearing. This is for non-payment of rent, and the parties have entered a consent judgment. Is that correct?
That is correct, Your Honor.
Can you place the terms on the record, please?
Yes, Your Honor. And so this is a non-payment case for possession only. We've got a rent to retain on this consent judgment in the amount of $330. Court costs in the amount of $182.04, giving us our grand total here today of $512.04. We've got language in paragraph 10 giving a payment plan breakdown. Defendants pay $100 on or before September 8th of 2025, with the remaining balance, September's utilities included, on or before September 30th of 2025. If paid timely, parties agree to stipulate to set aside this judgment and dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. The 56-day rule is waived. Defendant has added her signature to this resolution, and we did go over MCR 4.201J.
Okay, so you chose to do it as a consent judgment versus a conditional dismissal?
That's correct, but with the same outcome at the end of the day, assuming that it gets properly taken care of. Defendant simply has to email me to let me know that she's got the balance taken care of. We'll do a stipulated order to set this judgment aside to dismiss this case.
So this requires her to email you and you to get it dismissed after she pays?
Correct. To
Why
address
not
the-
your client? Why wouldn't it require your client to notify you that she's paid?
So it's just a responsibility that I've put on defendants for the past year or two. It's just a way of saying, hey, when you get this balance taken care of, reach out to me, let me know. And it also begins the stream of communication between myself and the tenant so that the tenant's aware of how this thing's unraveling.
There's a judgment then. If she's done what the agreement said and she doesn't reach out to you and your client doesn't tell you who, they should have a responsibility. It should be put on them. She's paid in full. I need to see that the client needs to have some responsibility and not just the defendant, if judgment is going to enter.
So you'd like me to add in language that indicates that my client's to reach out to me once the defendant has.
Absolutely, they're the one receiving the payment. Don't you have to confirm from them?
Yeah, I'd be confirming with them anyway.
Correct, so that they should be notifying if she's paying full, not her.
So
She could tell you she's paid in full and she's not.
Correct, but this is a benefit that we're providing in the first place. It seems like providing this benefit would then result in the understanding that, hey, you just reach out to me to make sure we get this properly addressed.
I recognize what you're saying. This is a court that we have a eviction diversion program.
Okay.
And I recognize that's one of the ways that you're choosing to resolve this, but we also have an option to choose to do a conditional dismissal. You're still offering the terms of a conditional dismissal,
Right.
Only that to the defendant's disadvantage, there will be a judgment up front against her. She's gonna, if she agrees to this.
Correct.
Versus a dismissal, and then if she doesn't follow through, then judgment enters. And so now you're putting the responsibility on her to now reach out to you to tell you that she's paid, for you to then have to confirm with your client, when you can just have your client reach out to you.
Yes, Your Honor,
And
just simply
confirm.
send me an email letting me know that she's got the balance taken care of. Is that too much in this instance, Your Honor?
I'm not saying that she shouldn't. I'm saying I want to know I want language that your client is going to reach out to as well.
Okay.
To make sure the responsibility needs to be also on your client. They have to confirm that they received payment.
Fine. So the language has been added. I do apologize, Your Honor. I thought that just putting the language in the first place was a nice show of respect and benefit as far as making sure that this can get set aside and dismissed. But I do understand you want a little extra padding into it. So I've added language. Property management is to email counsel upon receipt of full payment.
Yeah, I want extra padding because my preference in a court that does a diversion for eviction is to prevent people from being evicted. And so if I need her to just pay her rent so that she doesn't be evicted, I don't want to then put the onus on her to get the case dismissed after she does that. I want the responsibility on her to pay her rent. All the other responsibility to get the case dismissed, I want that on the attorney. I don't want it on her.
Understood, Your Honor.
I don't know if she'll have internet. I don't know if she'll have a working phone. I don't know what will take place to get her rent paid. What I want is to make sure that once her rent is paid, if she doesn't have a mechanism to email you, that you're still taking the responsibility to get this case dismissed.
So should it no longer then be a stipulated order?
What do you mean should it no longer be? Well,
The way that we set aside the judgment, dismiss the case would be with a stipulated order, which would require her to have some sort of communication with me in the first place. That's partially the reason that the email is kind of beginning that process of communication for us to get that properly drafted up. And so then we just submit an order that would set aside the judgment and dismiss the case, and it wouldn't be stipulated.
No, you're gonna dismiss the case. It doesn't have to be stipulated. It could be, you can dismiss it in a number of ways.
Okay, so
it could be dismissed by plaintiff. It could be dismissed by stipulation. It doesn't matter to me how it happens.
Okay, so
if what you're doing is a reverse version of a conditional dismissal, she's
right.
Gonna have judgment enter up front versus if you did a conditional dismissal, judgment would not enter in unless she failed to comply.
Correct.
That's fine, but what I'm saying is that I don't want the onus to then be placed on her, that she could still pay her rent, but if she doesn't email you, this judgment's gonna stay on her record. That's what I don't want, because we don't know her circumstance and what she has to go through to get the rent paid. She may not even have a mechanism to email you at that point. She may have to let her cell phone be disconnected to pay her rent. She may have to let her internet go to get the rent paid. If she, ma'am, I'm talking, put your hand down. When the rent is paid, it should not be, I don't want it to be her responsibility. It should be your responsibility and your client's responsibility to, after she's done what she's done, which is to pay the rent, to get the case dismissed if that's the agreement. You pay your rent, we'll get it dismissed.
All right.
Is it relative to anything that I just talked about? Is that yes?
I don't owe them nothing.
So why in the world are we here in the first place?
I don't know. I'm sorry. I'm trying to be disrespectful. I don't owe them anything. I just signed my name to pay for something. I don't owe them anything.
Well, then you can't do that. What's the issue? Not for you. You don't have to prove your he has to prove it. What is the
I'm sorry.
It's supposed to be past due rent?
Yes. I don't owe them money.
So she had a rental portion for a period of time that was not paid, that in combination with late fees being added on, late fees being below $21 a month, in addition to the court costs and.
No, it's not, ma'am. You have to relax. What is the amount that you're saying she owes past due?
So the rental amount that she's owing is $330. With the court costs is $512.04.
And the ledger is this is from late fees?
No, this is from her rental portion in addition to late fees.
Okay, so she's on Section 8?
Correct. She's got a zero balance currently, but that wasn't always the case, or a zero rental rate currently, but that wasn't always the case.
Okay, when did it become the case that she had to pay? Or when was it that she was paying and then she stopped? What was her amount that she was supposed to pay?
So the last payment that I can see was back in November of 2024. And the rental rate at that time looks like it was $24 a month.
She was supposed to pay $24 a month back in 2024?
Yeah, back in November of 2024. And it didn't, her rental rate didn't drop to zero until, looks like June was the first.
Of this year?
Correct.
Okay, and so you're saying that she owed $24 and didn't pay in December, January, February, March, April, is that what you're saying?
That is correct.
Okay. Ma'am, is that your belief that you owe you paid $24 a month back then?
So I paid them $24 and I paid it up like, it was like, I had paid a bulk, like 160 or something. They said it was 24, but then they said it was 27. And then they said I was supposed to be paying 27, but I never knew that. I only knew the 24.
How is she notified of how much she's supposed to pay? Good, I'm asking you.
I'm not sure off the top of my head, Your Honor. She's provided me a document of notification of that payment, so I know that she is getting notifications, but I don't have a specific one on me. I know that.
She's provided you documents of how much she's supposed to pay?
Correct.
And how much was it?
They said 24.
Okay, the document that you have it with you now? It says 24? Is that a yes? Or on the record, so you have to say yes or no?
Yeah.
But you don't have anything that says otherwise?
No, I don't have anything that says otherwise.
Can I?
Well, then, no, ma'am, then I'd have to go with her amount. You don't have any evidence otherwise.
Right, but I just said that it's 24.
Yeah, so she's supposed to be paying, so where's the late fee then? She said she was paid.
So no, she paid back in November, but there hasn't been a payment since that time.
Did she make a lump sum in advance payment?
She made a lump sum payment, but it didn't zero out the balance.
When was that? And how much was it?
That was November of 2024, and it looks like one payment of $148 and then one of $60.
148 and 60, both in November?
Correct.
Was she behind when she made that payment?
Yes, she was, though there was an error that occurred in resulting in that. She went to regular rental rate back in May of 2024. That was removed from this balance.
Okay, who's your witness?
Here today for a trial.
This is a hearing.
So I don't have a client with me at this time, Your Honor.
Well, how are you gonna prove your case if you didn't have a client?
I expected to be able to get to a resolution. It's my understanding that when we set aside the default judgment, that the concern here was the 893. We removed the 893. We agreed that that was improperly placed on the ledger, and so we had to balance that. To my understanding, wasn't being questioned in the first place from the previous hearings that we'd had leading up to now.
I don't know where you got that from. This was set for a hearing.
Right, from a default judgment that was previously set aside on the.
I recognize that. They were set aside.
Correct.
We moved on past that.
Correct.
I found good cause of meritorious defense.
Correct.
That doesn't mean that you no longer have to prove your case. And you can't prove it through your testimony. You're not a witness. You were supposed to bring your evidence and present it to the court. How are you going to present it? Because we have to have a hearing. She said she doesn't owe anything, and you don't have any evidence. So the case is dismissed. You're all set.
The case is dismissed.
Today is the date set for a hearing. You brought nothing for a hearing. You don't even have a witness. Is your client here?
No, my client's not here.
Do you have a client here for a hearing?
I do not, but I don't have a hearing.
Yeah, but if you were having a hearing, would you bring a client, Mr.
Yes.
Mr. Whitty? Would you bring your client if you had a hearing scheduled?
I sent both of them away, so.
After you resolve, not before?
Correct.
You didn't appear with a witness at all.
So it couldn't be adjourned. This isn't something that could be rescheduled.
Today was the date set for a hearing.
After the default judgment.
You did not you've not request. If you mention one more time that a default was set aside, she had good cause and a meritorious defense.
And I'm not arguing.
Yeah, so why do you keep bringing it up like I don't know that?
I assumed that what was addressed at that hearing was the 893 that needed to be set aside. We had then set that aside. I was under the mistaken
What happened
assumption
at that hearing was for her to provide me good cause and meritorious defense. I didn't hear any proofs about whether or not she owed money or not. That was what the hearing was for.
I understand. Thank you, Your Honor.
Thank you.
Thank you.
You can wait for a copy of a dismissal if you like. Wow, that's just slow. telling me it's locked because of you're not in the case.
I'm not in the case, I'm not sure.
This document is locked by L.
I'm not in the.
You have to log out of whatchamacallit, otherwise it's not gonna release it. On the record in the matter of Styles Roof versus Carolyn Black, 25-03-202, appearance plea.
Good afternoon, Your Honor. Robert Akanicki, attorney for the plaintiff.
Okay, and you are Carolyn Black? Okay, today was date set for a hearing. Did you all resolve this?
We did, Your Honor. This was filed as a non-payment case, but Ms. Black has agreed that she's going to waive any right to repayment. She can test any amount owed, but she's going to waive any right to repayment, and she's going to vacate on or before August 31st. And we're going to do that via conditional dismissal. If she doesn't vacate by the end of the day on August 31st, I could file an affidavit with the court and a writ and a judgment could enter. And Ms. Black has given me permission to sign her name to such a conditional dismissal, and I can submit it via my file.
Okay, that's how you want to proceed, ma'am? You want to vacate by August 31st? You understand that you have to vacate, turn over the keys on or before that date in order to keep this case dismissed? And that if you leave any of your personal items or you fail to vacate by that date, judgment can enter against you? You will not get another court date? You understand that? You also understand that if you intended to bring any claims, such as, I think you allegedly stated there was a belief that you had proof of unlawful reason to withhold rent. You waive any of those claims at this time. You understand that? Okay. Is anyone threatening you to get you to waive your hearing or your trial at this time? Any promises extended to you to get you to waive it? You also understood that you could be represented by an attorney today, and you appeared without an attorney, correct? So you're waiving an attorney to represent yourself? Okay. You have 3 business days from today's date. If once you leave here, you realize you misunderstood your rights, you can return to the court, request to have this set aside and explain how you misunderstood your rights. Lastly, you've given Mr. Akanicki permission to sign the conditional dismissal on your behalf, correct? Do you have any questions for the court? Any additional matters for the record, Mr. Akanicki?
No, Your Honor. Thank you.
Thank you. You're all set. This is the matter of SNS Positions versus Charles Tim II, 25-3293, appearance, please.
Thank you, Honor. Good afternoon. Sam Dewey here on behalf of plaintiff.
Your name, sir?
Charles Timms II.
Okay, Mr. Timms and Mr. Dewey, this was a hearing for non-payment of rent, but I understand there's a conditional dismissal.
Yes, Your Honor. I had an opportunity to meet with the defendant. We had a pleasant conversation about the past due rent. And we have both come to terms on the, both parties have signed a consent order for conditional dismissal for your review and approval. Said agreement says that rent due through the end of August 2025 is $4,694. Costs are $252.40, totaling $4,946.40. Box 3 is marked to show that the defendant will pay $950 every 2 weeks, starting on or before Monday, August 18th. Normal rent and late fees will accrue per the lease agreement starting September 1st, and payments will continue until there's a zero balance. Defendant has waived the 56-day rule. Box 4B is checked. Box 7 is checked. I have explained both of those to him and obtained his signature on the document. May I approach?
Thank you.
Thank you.
Mr. Timms, what Mr. Dewey said on the record is accurate as to how you want to proceed today?
Yes, Your Honor.
So you understand you did have the right to appear here today represented by an attorney? Have you waived that right today? You also have the right to proceed to hearing, or you could have demanded a jury trial. You understand that? You want to waive your right to hearing and jury trial? And no one's threatening you or promising you anything to get you to do that? Okay. You're going to pay the past due rent, $4,694 plus court costs, $252.40 for a total past due amount, $4,946.40. That's for rent due through a period of August 3rd, that you will, again, pay $950 every 2 weeks, starting on or before Monday, August 18th. Your normal rent and late fees to accrue. And it says per lease, starting September 1st, payments will continue until your balance is zero, and you waive the 56-day rule, correct? Okay, partial payment or performance of this agreement will not satisfy, meaning if you don't make those payments on or before the dates you said you're gonna make, and you didn't make the amount or more than what you said you're gonna make, then they can request a judgment to be entered against you. You will not get another court date, and they can then use that judgment to remove you from the property. You understand that? Do you have any questions? You have 3 business days from today's date to return to the court if you misunderstood your rights and request to have this set aside, okay? You're all set. Thank you.
Thank you, Your Honor.
On the record in the matter of Edward Rose Associates versus Miguel Maltan, 25-03731. Appearance, please.
Good afternoon, Your Honor. Norman Woody appearing on behalf of the plaintiff for Richard Herman's office.
What's your name for the record, please, sir?
Miguel Maltan.
It was the date that was scheduled, and this is for a hearing for non-payment of rent. And how did you resolve it?
Your Honor, I'm pleased to report the parties agreed to a conditional dismissal in this case. In terms are as follows. There's rent to retain in the amount through the end of August in the amount of $1,266.25. Court costs are $172.04. Total amount to retain is $1,438.29, which needs to be paid by August 25th, 2025. If he pays that amount by that date or vacates the units if he only has possession, he would satisfy the conditional dismissal. When the case is dismissed, it stays dismissed. He understands that if he doesn't do that, we'd have the right to come back and ask the court to enter a judgment and order of eviction, and that would happen without further notice and without further hearing. Partial payment wouldn't prevent us from doing that. And we did discuss Mr. Malton's rights under MCR 4.201J, after which he signed the conditional dismissal, if I may approach.
Yes, thank you. And Mr. Malton, what Mr. Woody said on the record is accurate in your understanding of how you're going to proceed?
Yes, ma'am.
You understand that you had the right to be represented by an attorney today? You want to waive that right? You had the right to proceed to a hearing, or you could demand jury trial, or you could have demanded jury trial. You understand that? You want to waive that right as well? Okay, so the case will be dismissed upon the condition that you pay the past due rent plus court costs in total $1,438.29, and that's for rent due through a period of August 25th, 2025, correct? Partial performance or payment of this will not satisfy. That means you won't stay dismissed if you don't pay that in full before the date of August 25th. You understand that? You have 3 business days from today's date to return to the court to request to have this set aside if you misunderstood your rights. Do you have any questions for the court? Any additional matters, counsel?
Nothing further, Your Honor. Thank you.
Thank you. You're all set.
Thank you.
No one else is ready yet?
Your Honor, we're ready to go on the Birchfield matter.
The
JLTT
okay.
Birchfield.
JLTT Birfield versus Crystal Robinson, 25-03966.
Good afternoon, Your Honor. Norman Woody appearing on behalf of the plaintiff JLTT Birchfield LLC.
And you are Crystal Lynn Robinson?
Yes.
Okay, how are we proceeding, counsel?
Your Honor, I'm pleased to report the parties have agreed to a consent judgment in this matter on behalf of the terms on the record.
Yes, please.
Rent to retain possession is currently due in the amount of $4,100. Costs in this matter are $240.24. Total amount to retain $4,340.24 to be paid by August 25th. We also requested a money judgment in this case. Prorated rent through today's date is $3,432.26. Court costs are $240.24. Total amount of the money damages portion of the judgment is $3,672.50. We did go over Ms. Robinson's rights under MCR 4.201J, after which she signed the consent judgment, if I may approach.
Yes, thank you. Ms. Robinson, is that accurate as to how you want to proceed today? Okay, so you have the right in this matter to be represented by an attorney. You understand that? You want to waive that right? Do you want to waive the right to an attorney? Okay, you also have the right to proceed to a hearing or a jury trial. You could have demanded a jury trial. You understand that? You want to waive that right as well? No one's threatening you to do that.
No,
No promises if you waive those rights?
no.
Okay, so you understand that judgment will enter against you by your consent and whereby you owe the past due amount of $4,100 plus court cost $240 for a total of $4,340.24. And that you'll pay that in full or vacate the property by August 25th, correct? Money judgment will also enter against you in the total amount plus court costs of $3,672.50. Okay, you have 3 business days from today's date to return to the court if you realize you misunderstood the rights that you waived, okay?
Okay.
If you have any questions at this time,
Come on.
get your copy of the paperwork, any additional matters, counsel.
Nothing further. Thank
Thank you.
you.
That's ready on Carolina.
On the record in the matter of Carolina Flats versus Griselda Perez, 25-02701. Appearance, please.
Good afternoon, Your Honor. John Wilburn, P83143 for plaintiff.
This is Ms. Griselda Perez. Hi, okay, today was the date that was scheduled for a hearing. Let's see, did you all resolve this?
We're actually going to be dismissing, Judge. Ms. Perez informed me that she has vacated. I don't have that dismissal with me, so I did want to just go on the record and advise we would be. Okay. And she has advised that my client is able to take possession, and I believe she has a key to turn over.
You have your key today? You've taken all your personal items out of the unit? Did you schedule a walkthrough or did you want to do that?
I would like to, we could do that today.
You should, it's for your own benefit. There's actually dismissal paperwork over there. Okay, so we'll get your copy dismissal in just a moment, okay?
To her for the past 3 balances, that when you come back and present the rest of the evidence, the wrong date paperwork.
Well, they dismissed it, so.
Oh, she just wasn't sure if they could come back for her for past rent. Does this put an eviction or is that just?
It's dismissed. It doesn't put an eviction on your record. I don't even know if they filed for money judgment. It may have just been for possession. Let me see.
That is correct, Your Honor.
Yeah, it might, yeah, it was just for possession.
Thank you. We just want to make sure we completely understand.
Nothing there yet. Yeah, he's up to it. Yeah, he won't be. Attorney Smith, he's out talking. Well, all his are here, but he's out talking to Sankey and Sankey.
Sounds good. Mr. Woody has some more.
Yeah, he's out there working on his too.
Sounds good. Okay, let's see, on the record in the matter of Edgewood at 1010, or Edge at 1010, versus Ashley Deering, 25-04065, appearance please.
Good afternoon, Your Honor. Roger Smith, appearing on behalf of the plaintiff.
Okay, you are Miss Ashley Deering. Okay, today was the date scheduled for a hearing for non-payment of rent. My understanding is that there was a conditional dismissal. Is that accurate, counsel?
That's true, Your Honor.
What are the terms?
Your Honor, the rent to retain possession on the conditional dismissal is $1,298. Court costs are $248.55. Other money due is $403.51 for a total of $1,950.06. Due on or before August 31st.
Is that accurate?
Yes.
Okay. Do you understand that you have the right to be represented by an attorney today? You want to waive that right? You have the right to proceed to trial or a hearing. You could have demanded a jury trial. You understand that? Is that a yes?
Yes.
You want to waive that as well? Okay. And you also understand that partial performance of this agreement will not satisfy. So you have to pay the amounts that you say you're going to pay, plus all utilities and late fees by the date that you'll pay them. Otherwise, they can have a judgment entered against you without notifying you of a new court date. Do you understand that? Okay, so again, past due amount plus court costs and other money due, and that's for rent due through a period of the 31st of this month. It's $1,950.06. Defendant shall pay amount in section 2D plus all utilities and applicable late fees on or before the 31st. If defendant fails to pay all amounts due, plaintiff may proceed with eviction without further notice. You have 3 business days from today's date to return to the court if you realize later you misunderstood the rights that you've given up, okay? Do you have any questions?
Nope.
Any additional matters, counsel?
No, thank you.
We'll get your copy in just a moment, ma'am. You still have Nikisha Foy here.
I do, Your Honor.
This is Lerner Way versus Nikisha Foy, 25-04044. Appearance, please.
Your Honor, Roger Smith, attorney for the plaintiff, Manor Way Properties.
And you are Ms. Foy, is that correct?
Yes.
Okay, this was an eviction for non-payment of rent. How are we resolving this?
Your Honor, I have a conditional dismissal. Oh, I'm realizing it's a typo. I'm gonna need a moment. Your Honor, would you like me to place the terms on the record or just?
Yes, please.
Your Honor, in this matter, the rent owed by the defendant is $7,200. Court costs of $247.50 and other money due of $100 for a total of $7,547.50. Again, the defendant agrees to pay the amount to the plus all applicable utilities and late fees on or before August 28th, 2025. Defendant fails to pay all amounts due on or before August 28th, 2025. Plaintiff may proceed with eviction without further notice.
Very good, thank you. And again, that's accurate as to how you want to
Yes.
proceed? Okay. You have the right to be represented by an attorney today. You understand that?
Yes.
You also have the right to demand a jury trial, or you could have had a hearing today. You understand that?
Yeah.
Do you want to waive those rights in order to have this matter dismissed with the conditions that you'll pay the past due rent?
Yeah.
Okay, so again, past due rent for a period through the 31st of August is owed plus court costs and other money, a total amount $7,547.50. Defendant to pay that amount plus applicable utilities and late fees on or before the 28th of August 2025, correct? So you understand that if you don't pay it in full, or by that date, or before that date, that judgment will enter against you. And they can use that to remove you from the property. You understand that? Do you have any questions?
No.
You have 3 business days to return to the court. If once you leave here, you realize you misunderstood your rights, you can return to the court, request to have the judgment set aside, okay? Or the agreement set aside, okay? Do you have any questions?
No.
Okay, we'll get you a copy in just a moment. Do you have another one?
I do.
Sankey?
Same.
Okay, this is Edge at 1010 versus Tammy Sankey and Shaquista Sankey, 25-04064.
Good afternoon, Your Honor. Roger Smith, attorney for the plaintiff, Edge 1010.
Your name, please?
Tammy.
Okay, your name is? Okay, and today was the date that was scheduled. This is for a hearing for non-payment. How are we proceeding?
Your Honor, we have a conditional dismissal prepared. Rent to retain possession in this matter was $2,709.07. Court cost was $208.90. Other money due was $395.94, for a total of $3,394.91. That is payable on or before August 28th, 2025, including all other applicable utilities and late fees that accrue on or before that date. If the defendant fails to pay all those amounts before that date, plaintiff may proceed with eviction without further notice.
Okay, and this Tammy is what he said accurate?
Yeah.
What about you, Ms. Shaquista?
Yes.
Oh. Okay, you both have the right to be represented by an attorney today. You were advised of that during your pre-trial. Did you want to waive your right to an attorney?
Yes.
You also both have the right to proceed to a hearing, or if you could have demanded a jury trial. Did you want to waive your right to trial in this matter?
Yes.
Is anyone threatening you to waive these rights? Any promises if you waive the rights? Okay, so you understand that the case will be dismissed today upon the condition that you pay the past rent that's due, plus the court costs and other money, for a total of past due amount of $3,394.91, that you'll pay that on or before August 28th, 2025, correct? Okay, partial performance will not satisfy this, meaning if you don't pay that full amount, and if you don't pay that full amount on or before August the 28th, plaintiff can request judgment to enter against you. You will not get another court date. You understand that? Do you have any questions for the court? Okay, you have 3 business days to return to the court to request to have that set aside if you find out later that you misunderstood your rights, okay? Okay, we'll get you a copy of the paperwork in just a moment. Is that all? Mr. Smith,
Your
is
Honor,
that
I do
all?
have one more, but it's at 3:30.
Are you here for,
Cam Moore?
oh, on behalf of, okay.
We have, Lloyd Thurman and Courtroom.
Thurman?
Did they get a copy?
I'm doing it now.
Okay.
I thought there was a stipulation on it.
All right.
So which one? Dirty alternate? And.
Oh, actually, yeah, they good. They right, yeah, they.
So what's your name?
Leroy Thurman.
Who is Courtney Holland?
She's in the car with our kids. Our son's at surgery.
Did you talk to the plaintiff's attorney?
Yeah, he called yesterday and today and said that it was supposed to be adjourned, but we were unclear because he didn't text us till this morning. And I just didn't want to miss court because.
What do you mean he said it was supposed to be adjourned? Did he request for you to allow him to adjourn it?
He asked us twice, but he said, then he asked if we agreed to the payment, but SER, we paid.
That's not what I'm asking you. I want you to only answer what I'm asking you.
Oh,
Did you agree to have the case reset?
yes. Courtney did.
Okay. She did?
She did with the attorney.
Okay, so that was what he told us.
Okay.
Okay, so we can get you a report date.
Oh, yes.
Hang tight.
I did August 27th.
August 27th at 2:45, okay?
Thank
No problem. And then you said you've applied for assistance?
Oh, we had got the assistance. I have the, we paid the money and they paid their part. So what we're going to court for is already paid for. That's why.
So your balance is zero?
Yes. That's why I was confused and want to come up here, because at the end of the message, she showed me, he asked, are you good with the amount? And we know we don't pay it.
And you have proof that your balance is zero today?
Yes, I have the paper that they agreed to, and I can go back
That
downstairs.
who agreed to?
The state of Michigan State Emergency decision. What they
Okay.
asked for. And
You
then-
should go and get a copy of your ledger today
Okay,
to show that it's zero today. And you need to bring it on the next court date, because if it was zero today, then they should have dismissed the case. But if it doesn't get dismissed, it's because you didn't go and get proof that it was zero, okay?
Okay.
So get proof that it's zero, and we'll come back at your next court date on the 27th, okay?
well, I just bring the ledger here with court or shut.
Yeah, you get a copy to show that it's zero, and you'll come back on the 27th with proof that it was at zero as of today,
Okay, thank you.
okay? You're all set.
Nice to meet you.
Yeah, no worries. You might need to get a new fountain pen though. Let's see here. Mr. Grabowski, is what Mr. Whitty said accurate?
Yes.
Okay, so it looks like here, the case will be dismissed upon the condition that you pay the past due amount plus court cost, $2,604.50, correct? And that you'll pay that according to the conditions in section 3. You'll pay $300 per week starting September 22nd and continue until the balance is paid in full, correct?
Yes.
And that payments will be first applied to your current month lease and then charges, and then the arrearage. Okay, is that accurate? You have the right to be represented by an attorney today. Do you understand that, right? You also have the right to proceed to a trial. You could have demanded a jury trial. Do you understand that? You want to waive both of those rights?
Yeah.
Anyone threatening you to do that?
No.
Any promises if you waive those rights?
What's that?
Any promises to get you to waive your rights today?
No.
Okay, you understand partial performance won't keep this dismissed. You understand that?
Yes.
Okay, do you have any questions?
Okay.
You have 3 business days to return to the court. If once you leave here, you realize you misunderstood your right, you can return and request to have this set aside, okay?
No problem. Thank you.
Okay, we'll get you a copy in just a moment, sir. Thank you.
Your Honor.
And let's see.
Just wait.
Okay, this is 3031 versus Michael Griffin, 25-04120. Appearance, please.
Good afternoon, Your Honor. Robert Whitty, appearing on behalf of the plaintiff 3031 LLC.
State your name for the record, sir.
Michael Griffin.
Okay, today was the date scheduled for hearing. This is for non-payment of rent. How did you resolve this?
Your Honor, it looks like the primary issue in this case is that Mr. Griffin thinks he very well be right, that he made his June payment, we didn't book it. He also says he's moving out on the 1st, and this is a possession only case. So what we'd like to do is kick this to a date in September. And I think it's very likely that between now and then, either because we find that payment or he moves out, we're just going to dismiss the case.
September 10th at 1:30.
September 10th at 1:30.
Thank you, Your Honor. Appreciate it.
No problem. Do you have any questions for the court today, Mr. Griffin?
No, ma'am.
We get your notice to appear. Any additional matters, counsel?
Nothing from the plaintiff here. Thank you.
Thank you so much.
Appreciate your time today, Your Honor.